Hi everyone, I'm happy to hold this great event about public procurement, Ukraine and European Union system. Today we are going to talk about next topics, Ukrainian and European Union market of public procurements, ability for Ukrainian companies take a part in European Union tenders, and of course the UK tenders. How does it work? Ability for European Union companies take a part in Ukrainian tenders. How does it work? So we'll discuss about procurement in Ireland, Great Britain, Poland, Germany, and Ukraine with the leaders of this field. Our speakers: Philip Lee, the partner at Philip Lee LLP Ireland; Rebecca Carter, partner at Stephenson Harwood LLP UK; Serhiy Sokorenko, project manager at Newtent Authorized Electronic Platform Ukraine; Anna Szymanska, partner at Dentons, Poland; Erna Deni Kamaga, consultant for public procurement at IMTB Consulting, Germany; and I, the moderator of this event, Mikita Zhukov, head of the Committee on Ukrainian Bar Association, expert in Ukrainian public procurements. The purpose of our event, in addition to the exchange of experience, is to demonstrate the similarity of public procurement system in Ukraine and some foreign countries, as well as to talk about equal opportunities for the participation of foreign companies in Ukraine tenders and Ukrainian companies in foreign tenders. Today, Ukraine is experiencing difficult times related to the military aggression of the Russian Federation. However, public procurement still proceed to exist, and Ukraine still remains an interesting country for the possible participation of European companies in Ukrainian procurement. At the same time, today Ukrainian business try to expand the geography of activities and are interested in new markets like European countries and the UK, particularly the procurement system of these countries. In the context, little spoiler: in many points, legal regulation of public procurement in Ukraine has common features with European legal regulation. These circumstances is stipulated by the fact that since 2014, Ukraine has taken the vector of European development, with the signing and ratification of the association agreement between Ukraine and the European Union countries. Public procurement in Ukraine began to be built under the rules of European directives. In fact, this led to the emergence of new legal institution of public procurements as life cycle, abnormally low prices, electronic auction, and more. Let's go into start and find out more interesting information. But before they start, I just want to say that in Ukraine we have some difficulties with electricity, which stipulated by the war. And as long as there is electricity and the internet, the right to speak first is granted Serhiy Sokorenko, project manager at Newtent Authorized Electronic Platform of Ukraine. So Serhiy, you have the floor. You're welcome.
Thanks, Nikita. Glad to see you, everyone, at this meeting. Now I prepared some presentation. 1 second. Tell me, please, do you see my presentation?
Yes.
Okay, great. Today, I would like to talk with you in general terms about the electronic procurement system in Ukraine and about our platform. This topic seemed quite relevant to us, despite the fact that Ukraine is currently at war with our geographical aggressor neighbor. We see great prospects and opportunities even now. And of course, after our victory and the beginning of restoration and development our country. About the system. In Ukraine, the electronic public procurement system is called ProZorro. It's a combination of two words and accordingly two meanings, transparently and Zorro. It's in some meaning like a fair Zorro. In this way, we get the basic idea of reforming the system which sound everyone sees everything. So the goal of implementing this reform was to eradicate and systematically prevent corruption, increase the transparency of the procurement process, switch to electronic auctions, avoid any discriminations of bids by participants, wide involvement of the public, and introduce an electronic auctions that provides for automatic evaluation of submitted bids. The main essence of this reform lies in the maximum transparency and accessibility for the procurement process, the interaction of authorities, business, and the public. So after the end of the tender, in the electronic system, you can see all the information about submitted proposals of the participants, any decisions of the tender commissions of the customer, all the qualification documents, the published contracts after auction, and other necessary documents. That's why this information is publicly available thanks to the analytics model and can be used to monitor the procurement process. About main type of procurement at this moment is it is competitive procurement, which is called open procurement. An integral part and of this open procurement, it's a live auction, or another word, this type of auction called Dutch auction, and main sense it's in reduction. This auction provides in 3 steps, and in any of these steps, each participant can do their bid. It's about main part and main time of procurement. So, in a few words, I want to say about our platform. It's Nutent. Our platform has been working in system since the beginning of the reform of the procurement system. It's since 2016. And our team took an active part in this process and continues to develop. In a few words about interface, some slides with main view, main page, some slides with a typical view of the tender page, and also we got really suitable search model. And with the help with this search model, you can find any procurements which you want. And some moments about our platform. The interface is in English, so it will be trouble-free for participants from all over the world. Automatic exchange of information, the documents in electronic form is ensured between the Nutent site and central database. The function of electronic platform is to provide users with access to the system in every point of the world. Regarding the work of foreign companies that are non-residents, the most important step is registration on our platform. And then, thanks to our customer support team, we will quickly and easily ensure that you participate in purchases that interested you. And of course, our legal and finance departments, we help with various legal aspects. We have all the necessary functionality and all additional features which you can need or will need for your fast and efficient work in the electronic public procurement system. In general, that's all what I need to say about our platform and our procurement system in Ukraine. Thank you for your attention. And if you have or will have any questions, we are always happy to answer them. Our contacts you can see on your screens, and you contact with me or our team with pleasure. Thank you. Thanks for attention.
Okay, yeah, thank you, Serhiy. And for our European colleague, I'd like to say that if you'd like to take a part in tenders, you need to enroll in one of authorized electronic platform, and one of these authorized electronic platform is NewTend. You can use another one, but one of them is NewTend. For today, we have one problem because our authorized electronic platforms has English version, English and Ukrainian version to use, but unfortunately, the central website Prozoro has only Ukrainian version, not English. But for today, we have our country have some recommendation from World Bank about future purchasing, which stipulated renovation in Ukraine. And I think that in foreseeable future, all tenders will be not only in Ukrainian language, but also in English language for our European colleagues, for our colleagues from UK and other countries. Yeah, thank you. Thank you, Serhiy. And next speaker is Philip Lee, the partner at Philip Lee LLP, leader, expert in the area of procurement, competition, trade, and construction law, Republic of Ireland.
Nikita, thank you very much indeed, and lovely to see you again. I had the great pleasure of having Nikita work in our office for a few weeks after he first left the war zone of Ukraine. All the people in Ireland have a huge sympathy for the Ukrainians, and you have, as a country, enormous support. I think there are 60,000 Ukrainians resident in Ireland now, which on a proportionate basis, if you compare it to the UK, would be almost 750,000. So they have integrated really well, and they're absolutely adored by the Irish. So we're very happy to help Ukraine in any way. So I've got quite a few slides, but I'm going to go through just 2 slides to give you some kind of an overview of what the law is like here and what might become relevant. So the source of rights to tender for public works actually comes from the EU treaty. And from that, even in existing tenders, whilst we have specific directives giving you specific rules, we always have an eye on the EU treaty principles. The main ones being the principle of proportionality. So there's a proportionality in how they might weight the criteria and how they treat people or how they eliminate people for a minor infringement. Transparency, which, as your previous speaker said, is fundamental to public procurement. That is that the tenders know and can understand what the specification is and the contract terms, and probably most importantly, what the award criteria are, because there's a lot of litigation in Europe over tenders, which is a good thing. It ensures there's no corruption and there's transparency. It is usually about the interpretation and the application of the award criteria. So those principles coming from the treaty are very important. We have, as I suspect everyone knows, directives that are reasonably specific, covering work supplies and services, and also a separate directive covering concessions, and most importantly, a separate directive covering the remedies. I don't know what it is in Ukraine in regard to remedies, but when the directives were first introduced in 71 and 73 in supplies and goods, respectively, or supplies and works, they were ignored throughout all of Europe. Lip service was paid to them. It wasn't until the Remedies Directive, giving an unhappy tenderer a simplified and fast and powerful remedy if they thought it had been unfairly awarded, that the directives bit. They became live, and every public body ran to their lawyers and was terrified at first because they really realized there could be challenges to their award system, whereas previously there weren't. So that really made the law. Big, big change. So the directives, as the word suggests, are high-level principles which the national member states must implement in their national rules. By and large, there's not a great gap between the national rules and the directives. And in Ireland's case, they're almost verbatim. There are some changes and some mistakes, but you'd always look at both the directives and the national rules. Sometimes the national rules might not have been correctly implemented, in which case the unhappy tenderer can look to the directives to apply the law. There is also out there the World Trade Organization Government Procurement Agreement, which you should be aware of, which is relevant and can be called upon if you're arguing something in court, because there should be consistency between the GPA and the European directives. So it's useful in terms of your rights if there's cross-subsidization, particularly if you're a Ukrainian company. State aid can sometimes become relevant. I won't go into it now because that's a separate area, but I did want to mention the last two, which could really be combined into one, which is green procurement. That is going to grow very fast in the next months and years ahead as Europe struggles to bring its carbon emissions down to zero by 2050, and by reducing it, I think, by 30% by 2030 or 35%. So you are seeing every day a growing interest in the particular criteria for selection, criteria for award, and conditions of contract, which impose on the supply chain managing and watching their carbon emissions. So I mention this to you because it's very real. And if a Ukrainian company is thinking on the work side in particular of doing business in Europe, they will be hit by green procurement, which they mightn't really have been ready for. So they need to understand that. And national governments will look at the European Green Procurement Toolkit, where they give them sample award criteria, selection criteria, conditions of contract. That's very important. I mentioned the treaty because that kicks in even when the contract that's being awarded is below those thresholds you see before you. Those are the thresholds where if the value of the contract exceeds that, they are triggered fully by the more detailed mechanisms of the European procurement directives. But as I said, even if you're below those thresholds, the principles concerning transparency, proportionality, non-discrimination are triggered anyway, and you have to comply with that, provided the tender is of some size that another person from another country could be interested. I'm just going to end on 2 slides, even though I'll leave you with more slides that you can look at in more detail, to give you an overview of what the procedures that can be available for awarding contracts looks like. You have quite a menu, including the open, which is the whole document. All the documents are published on the OJEU notice. You read everything, you put your bid in with and the selection criteria and award criteria are all together with the contract, and you put your bid in and you win or lose, bang. 2-stage step, you may be familiar with, we call it restricted procedure, where there are 2 stages. You're firstly selected, so it's more easily managed by the awarding authority, and you usually have 5 or 6 firms selected based on transparent criteria, and only those firms put in a bid, and then the decision is made. A competitive dialogue, CD, is really important for any kind of complex contracts. We have certainly found a slight resistance to its use, but we pretty well tell all our awarding authorities for any kind of complex contract to use the competitive dialogue. There's a slide that follows, which I'll leave with you through Makita, which gives you a bit more of a breakdown of the steps, but it allows, having shortlisted your bidders, to have detailed dialogue with each bidder so that they understand your specification and your contract terms, and you hear where they may have problems with your specification, your contract terms, and it allows for a much better outcome, because very often there could be one clause in your contract that some American bidders might not be able to accept because it's IP rights or things like that, or issues to do with GDPR. And you could find that if you don't change your contract, only one person bids and they're the most expensive bidder, and that's a problem. So the competitive dialogue should become much more frequently used. Negotiated is a bit like that, where you actually negotiate the prices with the bidders. There's not a huge gap actually in the practical terms between CD and negotiated. And then you have frameworks used hugely if you want to draw down contracts and you're a major awarding authority. So you could have a framework of architects or engineers, or even a framework of contractors. So you've already pre-selected them and just call for competitions to draw down from that, either by going to competition or sometimes based on their original proposals. You can just say, what's the best of those proposals? A dynamic purchasing system is usually for smaller goods where they have a rolling system to draw down. And then almost second last, innovation, or third last as it will turn out, innovation partnerships, rarely used, but allows you to work with a person who will develop a prototype of a new solution to your problems. And you can pay several people who have been shortlisted as they develop the prototype, reducing the number of people as the prototype develops, and eventually choosing one person from that iterative process. The key difference is that you're paying people actually as you are selecting and reducing 5 people who are working in a prototype to a smaller number who eventually get the job for that prototype. So it's quite advanced, quite interesting, not used quite enough. There is also a certain form of tendering we call light touch, which is available for certain types of social contracts, affects the health sector to a major degree, but also education. And in that category, most of the specific rules of the procurement directives are removed. So you have huge flexibility in terms of how you want to manage the procurement process, provided you're transparent, proportionate, and not discriminatory. So it's a very flexible system. Sadly, when it's available, many of the bodies that have a right to use it don't actually take the full advantage from what is conferred by the light touch. So there are other slides there that give you more detail about those different processes. I'll end with this last process, which is a non-process, which was used right throughout Europe widely during COVID, and I imagine must exist in Ukraine, because I imagine in Ukraine you are not doing tendering because you're in a dramatic emergency and there's no time for tendering. And so in that slide here, you see the triggers that allow an awarding authority directly negotiate. So pick up the phone to somebody and say, get me the bridge built tomorrow. Give me a price. I want to work just with you. So you can do that if there's only one person you can work with. That happens in IT contracts because you already have a built-in IT system and only one person can actually meet your needs. Or they have exclusive rights for a painting or something like that. It can arise if there's no suitable tenders, or when it's strictly necessary because of extreme urgency. The extreme urgency must be arising because of external factors, not because the awarding authority was incompetent and left it to the last minute or doesn't have resources. So if there's a third event or an event from a third party, such as a war, then extreme urgency probably does arrive. And then the final one, there's quite a wide entitlement actually to do a direct negotiation for the purposes of research and development, where some of the benefits remain with the awarding authority. So I'll end at that because I said it'll be very fast, but there are other slides there which might help you in due course. Nikita and others, thank you very much indeed.
Yeah, thank you. Thank you, Philip. It's really interesting presentation. And about Ukraine, for today, we have some peculiarities. We use open tenders, but big peculiarities because in regularly, we use open tenders, which regulated our parliament legislation act. But for today, we have a special act from our executive branch of authorities, cabinet of ministers, about peculiarities of open tenders. We use negotiation procedure, but for today we use more open tenders. Yeah.
Okay, that I would from an awarding authority perspective, Pete, I would say that's a pity because it's very clumsy. It's impossible usually to communicate everything to the 500 bidders who might put it. So I would, whilst it's still widely used as Ireland, we encourage most awarding authorities, unless you're buying army boots or pens and papers, to actually be more sophisticated in how you select and proceed.
Yeah, okay, thank you. And so the main question for today, is it possible for Ukrainian companies to take a part in Irish tenders?
Yes, no restriction.
Okay, great. Yeah, thank you, Philip. So our next speaker is Rebecca Carter, partner at Stephenson Harwood LLP, specializing in public procurement law in the UK. You are welcome, Rebecca.
Thank you. I'm just going to share my slides. Just need to go back to the beginning. Can you see those okay?
Brilliant.
Lovely, thank you. I'm just going to say thanks to Sandeep, who's been sitting patiently by me, making sure I don't make a mistake, because I'm technically not very able. So thank you, Makita. I just wanted to start by echoing Philip's comments in terms of support for the people of Ukraine at this time on behalf of the UK. And so I'm very grateful to Makita for giving me the opportunity to cooperate and help, even in this very small way. I do appreciate the opportunity. So thank you for the introduction. Yes, I'm a partner at Stephenson Harwood. I head the real estate and projects group here, and I specialise in public procurement law as well. For those who don't know Stephenson Harwood, we're a law firm with over 1,000 people, 8 offices worldwide, and we're headquartered in London, which is where I am now. I think the first thing to say is that regardless of what you may have all heard about Brexit, I hate that word, but we have to say it. The UK is still very much open for business, and there are many opportunities for Ukrainian companies, particularly selling to public sector customers, and that is very much the subject of our discussion today. So we are indeed open for business. For the moment, many of the rules around public procurement are broadly the same as the ones currently being used in the EU, as Philip has very ably described. So even though we've left the European Union, those rules broadly still apply for now. And that's because the UK legislation that implemented the procurement directives that Philip described into UK law have not yet been substantially changed. But we know that this legislation is going to be changing soon, probably at the end of next year. And I'll talk about that in a moment or two. So in terms of agenda for my section of the webinar, I'm going to talk about the size of the public procurement market in the UK and how to find out about the pipeline of planned projects. I'm going to cover the public procurement system currently in force in the UK and what's likely to change next year and beyond. And in each case, looking at these from the perspective of Ukrainian companies wanting to bid for UK public sector contracts. So first of all, what's the size of the opportunity for companies looking to bid for UK contracts? Well, in the UK last year, gross spending on public sector procurement was just under £4 million sterling, so a significant number. This isn't just central government departments, it also includes things like our National Health Service bodies and municipal authorities, for example. And don't forget also that within the UK, we have devolved nations in the form of Scotland, Wales and Northern Ireland. So we have separate legislatures and executives for those nations. And so this spending figure that I've got on the slide covers them too. So in other words, in the areas where these nations have devolved spending, their own government departments and other public sector bodies will be procuring contracts too that may be of interest. So this market is huge, but it's quite fragmented. And I guess the question is then, how do you find out more about the opportunities for suppliers and contractors to bid for these contracts? I'll cover in a moment how you find specific contract opportunities, but in terms of understanding what's in the pipeline for different parts of the UK public sector, individual government departments, municipal authorities and other public bodies will usually have a procurement pipeline of planned projects, and they'll usually publish that on their website. So for suppliers and contractors in the Ukraine, I think it's worth trying to work out which part or parts of the UK public sector are relevant to your particular industry or sector, and then take a look at the relevant website. And they'll hopefully have quite a detailed explanation of the upcoming contract opportunities that are in the pipeline. I think it's also worth mentioning that there are opportunities for small and medium-sized enterprises to bid for UK public sector contracts. The UK government's target is for at least a third of central government expenditure to be with SMEs. And for these purposes, an SME is an organisation that has fewer than 250 employees, a turnover of less than 50 million euros, or a balance sheet total of less than 43 million euros. And quite a lot of the UK government's public procurement policy post-Brexit is focused on making public contracts more accessible to SMEs. And this informs much of the new legislative approach that I'll discuss in a moment. So I think the message here is that there'll be plenty of opportunities for SMEs in Ukraine too. So that's all I want to say about the size and nature of the opportunity and how you might find out more about the contracts that are in the pipeline in particular areas of activity. So then just to look at the regulatory regime for public procurement in the UK and how that differs from what Philip has described for Ireland and the rest of the EU, and what that means from a practical perspective if you're looking to access these opportunities. So until the 1st of January 2021, that fateful day, while we were still in the European Union, we followed the same rules as the rest of the EU. Of course we did. Our legislative framework was made up of the public contracts regulations. There were other regulations as well, but these are the main ones. And these implemented the procurement directives that Philip talked about earlier. So the public contracts regulations cover England, Wales and Northern Ireland. Scotland has its own version of the regulations on its own statute book. And so far, since the 1st of January last year, the situation hasn't changed very much. So to explain more, we're still bound by the public contracts regulations, but they've been amended to make them work outside of the EU framework. So for example, UK bodies no longer advertise their contract opportunities in the official journal of the European Union, which was the e-tendering platform. We now have our own domestic portals for this. And I'll explain a bit more about those in a moment. So in other words, the legislation hasn't been amended. So the legislation has been amended to make it work outside of the EU, but there haven't been any more significant reforms at this stage. However, the UK government has announced that they will be using the fact that we're no longer in the EU to significantly reform public procurement, and this will lead to some changes that are relevant to suppliers coming into the market. So I'll talk about those shortly. So for the time being, the procedures that we use here are broadly the same as the EU ones, so the open, restricted, competitive dialogue and negotiated procedures that Philip talked about, so I won't go through those again. I thought it was worth mentioning electronic procurement because that will be relevant to companies bidding from Ukraine. Electronic procurement is strongly supported in the UK. All communication and information exchange for above threshold procurements at all stages of the procurement procedure have to be carried out using electronic means of communication. So that is the norm here. So I mentioned that UK opportunities are no longer advertised in the official journal of the EU. So instead, all above threshold contract notices have to be published on a UK government portal called Find a Tender. Contracts that are below threshold but above £10,000 in value have to be advertised on a separate portal called Contracts Finder. And then Scotland, Wales and Northern Ireland have their own platforms as well. And you'll see I've put those websites on the slide for you. Philip mentioned framework agreements, and as with the rest of the EU, they are commonly used in the way that Philip described. And in particular here, the Crown Commercial Service, which is part of the Cabinet Office, they use frameworks a lot. So they make it their business to set up frameworks that on behalf of the whole public sector, so that smaller public sector bodies can call off what they need from those frameworks. So if you can get yourself on one of those frameworks, this gives you quite a lot of opportunity, and then they're usually let for up to 4 years. So I've also put the Crown Commercial Service website on the slide for you. Philip's also already answered this question in relation to Ireland or the rest of the EU, and it's the same answer here in the UK. So both Ukraine and the UK are part of the World Trade Organization Government Procurement Agreement, and so this means that Ukrainian companies are able to bid for contracts in the UK in the same way that they could while the UK was still a member of the EU. One point I wanted to just particularly mention in this context is that in the UK, this is a bit like the green procurement side that Philip was talking about in the EU. So in the UK, under the Social Value Act 2012, all public bodies are required to consider how they can improve the economic, social and environmental well-being in their area through the procurements they run. And in many cases, this can mean that there are requirements in the tender documents that relate to what is being procured, but could also bring wider social value to the local area. So as an example, in a construction contract I've dealt with recently, there was a requirement that the contractor worked, as well as carrying out the works on the site and building the infrastructure that was required, they had to also work with a local college to provide work experience placements for students who were studying a related course there. And on the face of it, these sorts of requirements can sometimes look a little challenging for companies that are entering the market from overseas. So it's worth just bearing that in mind when you look at tender opportunities. But it's important to say that in any event, the public body must not use those sorts of social value requirements to discriminate against suppliers from other countries. And so they will be obliged to make sure that any social value requirements are drafted in a way that's fair and proportionate to everyone who's interested in the opportunity. So I've mentioned that the law governing public procurement in the UK is due to change. So we have a new procurement bill that was introduced to Parliament in May this year, and it's likely to come into force towards the end of next year. And the UK government has said that its key aim when updating procurement legislation is to improve transparency in procurement. In particular, they want to make sure that there's greater awareness of the pipeline of future work, current and future procurement opportunities in the public sector. They also want to create improved transparency of the whole life cycle of government contracts. So in the past, the procurement legislation has really just looked at the tender process, whereas this is now looking at the transparency of the whole life of the contract, so that we can see whether the final amount spent on a contract differs from the original intended value. There's also going to be a register of suppliers to be established, which will allow suppliers to input information about their businesses and answer questions that they're frequently asked when they participate in different procurements. And this is a way that this will have with a view to saving time for all concerned, and public bodies will be obliged to use these answers in their procurements. This is called a tell us once system. So the idea is that it will reduce duplicate work for suppliers, making bidding easier across all public sector organisations. And it also create a standard and updatable business record to feed information to a central digital platform, which will provide information about public sector contracts by size, type and location of business. And another key aim of the new legislation is to simplify the procurement process, but also make it more flexible. There's always been this complaint in the UK that one of the issues with being in the EU was there was lots of red tape and it constrained us and made life too difficult. So one of the stated reasons for this public procurement reform is that the government felt that the EU regime was stifling innovation and also hindering access to public procurement for small and medium-sized enterprises. And so one of the things the new bill is trying to do is to simplify the process by reducing the number of procurement procedures that are available to public bodies. So you will have seen on Philip's slide quite a number of different options that public bodies can use when they're advertising these contracts. So under the new bill, the proposal is that there'll be a single stage open procedure for simple so-called off-the-shelf procurements, and that will be broadly the same as the open procedure that Philip was talking about. If that isn't suitable, perhaps because it's a particularly complex type contract requirement, then the draft legislation states that public bodies can use such other competitive tendering procedure as it considers appropriate, which is certainly very flexible and open-ended. The procedure that's chosen must, however, meet all of the remainder of the rules in the proposed bill, and these largely reflect what we've seen in the EU regime over the years. So, proportionality, minimum time limits for returning tenders, and so on. So it's not completely open-ended. And I think, although on the face of it, having just these two different procedures simplify things, it certainly does achieve the aim of being flexible, so providing flexibility for public bodies. My concern is that in practice it risks the situation where, because the procedure that's not the open procedure, so the more flexible one, is so flexible, public bodies around the country will all choose their own approach, and so we'll have a multitude of different procurement approaches. So we may end up actually with even more than the EU situation. So I'm yet to be convinced that this will achieve the intended objective, but hopefully I will be proved to be incorrect. It's also worth noting that the procurement bill covers all public bodies in England, Wales and Northern Ireland, and much as it does now, the Scottish Government has opted not to join the bill, and so we can assume they will be publishing their own procurement regulations in due course. So in summary, there's a very significant market in the UK for public sector contracts. Notwithstanding Brexit, there are still lots of opportunities for companies in Ukraine to bid for, and we would very much welcome that. To find out about these opportunities, I would recommend, as I say, working out which part of the UK public sector is relevant to the services or products that are being sold, and then do some online research to have a look at the published pipeline of opportunities, and then look at the relevant portals that advertise the specific contracts to participate in those opportunities. And for the moment, the procurement processes are largely the same as for EU tenders, but they will change next year. And as a firm, we've been publishing updates on our website as this legislation passes through the parliamentary process. So do feel free to have a look at those if you want to follow how we're getting on in the UK. And thank you very much. I'll hand back to Mikita.
Yeah, thank you. Thank you very much. It's very interesting presentation, so exciting. I have one question. I think that UK procurement is a very competitive market, but maybe you have some advices for Ukrainian companies to how to find some gaps in your market and be competitive in your UK tenders. And maybe you have advice for Ukrainian companies to pay attention for some areas of market, for instance, agriculture or IT or medicine, technology or something else.
Yes, that's a good question. I mean, I would say the sectors where we're most active are indeed technology, anything to do with decarbonisation, renewable energy, those sorts of areas. And also the life sciences sector is very active as well. So those are the markets where, there's probably room for new market entrants because they're slightly leading edge in terms of technologies and, just general developments. So those are the sorts of areas where we tend to need to look to countries outside of our small island to encourage participation. And yeah, so it's very competitive already in areas like, for example, construction, and those sorts of things can be harder for companies overseas to participate in because you would really have to probably set up your own subsidiary here and be based here. But for some of those other sectors like technology, life sciences, I would say those are good areas to focus on.
Yeah, okay, thank you for your answer. So our next speaker is Anna Szymanska, partner at Dentons, co-leading of public procurement practice and the member of the Public Procurement Council at the President of the Polish Public Procurement Office.
Thank
you're
you.
welcome.
Thank you very much. I just wanted to make sure whether the presentation is on the screen.
Yeah, and if I make a mistake in pronunciation of your surname, sorry for that.
No, that was okay. I'm Anna Szymańska, so you are correct. I just wanted to make sure whether the presentation is visible.
Yeah.
Okay, so thank you very much. Greetings from Warsaw, which is very snowy today. And first of all, I would like to thank you for inviting me to present the Polish procurement market from the perspective of Ukrainian business. I'm convinced that this initiative is very valuable, like anyone that connect, builds, and broaden knowledge. So I do appreciate. As you mentioned, I am a partner at Dentons Warsaw, also a legal advisor admitted to the Warsaw Bar of Legal Advisors, and I practice public procurement matters since, I think, 2005. And today I will share some thoughts, some legal provisions with you in a very general terms with respect to Polish public procurement market, according to the agenda that you can see on the slide. So first of all, when we focus on public procurement, we should be aware that in Poland, it is regulated on the national law level by the public procurement law. As you might see, it's a quite new piece of legislation because it just entered into force since 1st January 2021, and it replaced the previous legal act that applied from since 2004. The new law reformed public procurement law, made it more readable, and focused more on the stage of performing the public procurement law, not only on the stage of the tender. The law is very complex act that regulates most aspects of procurement process in Poland. Among other things, it specifies entities obliged to apply the provision of the Act, the scope of exclusions from the application of the Procurement Act, the principles of awarding contracts, of course, that implements the EU directives like fair competition, equal treatment of contractors, transparency, and the fact that almost everything is public in Poland, so everyone from the street can just apply for the documents from the tender, for the other bids, etc. Of course, with some limitations like business secrets or other protected information. The law also regulates the stages of preparation of the tender, the whole process of conducting the tender, the contracts provisions, and last but not least, the legal protection measure system, which is very specific in Poland. However, for a second, I will zoom on the size of the market. The Public Procurement Office every year announced and published the statistics and some data with respect to the market, and with respect to the contracts awarded using the provisions of the Public Procurement Law. In 2021, it amounted to approximately 184 billion of Polish zlotys. 1 euro is more or less 4.5 Polish zlotys. Now is even more because of obvious reasons, but it's more or less like that. However, to give you a bigger picture to this amount, also additional about 111 billion Polish zlotys should be added to calculate also contracts that was public procurement contract that was concluded without application of the Public Procurement Act regime on the basis of exclusions, which are pretty much taken also from the EU law directives. With respect to the current situation, we see that the value of awarded contracts increased this year. In the Public Procurement Office website, we can read that in 2022, so far the value of contracts contracted exceeded 337 billion of Polish zlotys. It's more, it's about 10% of PGD of Polish in Poland. So it's a great piece of cake in terms of doing business in Poland. However, going to the structure of public procurement, we cannot omit the institution, which is Public Procurement Office, headed by the President of the Public Procurement, that plays a policy-making and coordinating role in the whole market and in the whole system. It's independent unit within the Polish government. The president of the PPO is appointed by the ministry, a minister responsible for economy, and the key duties are education, preparation of proposals to normative acts, also some initiatives relating to trainings in the field of public procurement, but also conducting a supervisory role over the procurement process. However, in Poland, public procurement entities like local government, other units of public finance are independent in the process of conducting procurement tenders. So the role of Public Procurement Office is, as I mentioned before, rather coordination and supportive. Going further, with respect to the types of contracts, we can distinguish the classic contracts, which are governed by public procurement law if its value is equal or greater than 130,000 Polish zlotys by the public contracting authorities. If the value of the procurement is below the EU threshold, then we call it national procurement, and it's published on a special public tenders bulletin conducted by the President of the Public Procurement Office. If the value of the contract is estimated value of the contract exceeds the EU thresholds, then it's published on the special website of the European Union in the Tenders Electronic Daily, and it's followed by the European regime. We also distinguish utilities contracts in the sectors like water, energy, mining, postal services, transport, and all the sectors that are covered by the utilities directive. And the obligation to follow the public procurement law starts if the value of the contract is equal or greater than EU thresholds. And last but not least, defense procurement, which is currently very important. The contracts in the field of defense and security are also regulated in the separate chapter of the public procurement law. They implement the defense directive, EU directive, and are very specific. For example, in defense tender, there is no possible to conduct the open procedure. The restricted one is the first choice of the awarding entity, and it also applies from the EU threshold. We can also distinguish PPPs in Poland and concessions for works and services, but those kind of contracts are regulated by separate legal acts. We have separate legal acts for PPPs and separate statute for concessions for works and services. That sort of contracts are not regulated by this main public procurement law. So with respect to the type of procedure, as in other EU countries, the contracting authority has to choose mainly the competitive procedures. The most important is open tender, where every interested contractor can submit its offer, and the notice is publicly available, as well as all tender documents like terms of reference, any changes, questions, etc. The non-competitive procedures like the single source procurement or the negotiations without prior notice are addressed only to some special limited circumstances, and not obeying these provisions limiting the possibility to use non-competitive procedure can end in invalidation of the whole contract. With respect to the procurement below EU thresholds, we've got very similar kind of and type of tenders. However, a little bit simplified and also called in different way. In most cases, the awarding entity use basic procedure that has 3 options. The first option is pretty the same as an open tender in the EU provisions. The second option gives the awarding entity the option to conduct further negotiations with the given contractors. And the third option is very similar to what we call negotiation with the notice on the EU level. And then we go to the electronic system of public procurement. In Poland, I can say that the procurement process is almost entirely electronic. 3 points are worth emphasizing in this context. First of all the announcements, all the notices about the tender, etc., are published on official EU or Polish website. The official journal of the European Union is conducted on the European level, the so-called Tenders Electronic Daily, whereas the national contracts are available on in the public procurement bulletin, which is conducted by the public procurement office. On the slide, you will find also the links to the website. Also, it's important to emphasize that right now we've got unified official e-procurement platform. It was recently started operating, and this is a place where all the tenders are now conducted electronically, with some exceptions, of course, as it usually is. The procurement platform is available on the website conducted also by the Public Procurement Office. You'll see the link on the right side of the slide. It's called e-zamówienia, which can be translated as e-procurement. And it's a quite interactive tool with many functionalities. You can just freely search tenders in this on this website. You can also log in or sign as a contractor to this platform. Even if you are foreign contractor, it doesn't matter. And third thing I would like to mention is that it's extremely important to possess an appropriate qualified electronic signature. It's essential because all the offers documents must be submitted in electronic manner with appropriate EU qualified electronic signature. And we know from the practice that sometimes it causes some problems. As I mentioned before, all this information, including the possibility of reviewing tenders, is available on the website, and EU tenders are also, of course, available on Tender Electronics Daily. I mentioned before that we've got very specific public procurement legal protection measure system. These are tools which are very widely used by contractors. The statistics says that about 3,000 up to 4,000 appeals are submitted by the contractors every year in Polish tenders. It's very competitive, and it's structured in a way that the special body of the first instance, named National Appeal Chamber, is dedicated to resolve procurement disputes, mostly still before the contract is concluded, which means on the tender stage. And actually, every type of action or omission of the contracting authority, which is, in opinion of the appellant, unlawful, can be challenged to the National Appeal Chamber. The process is very fast. Approximately 2 weeks is enough to adjudicate on the case. And the types of auctions of the awarding entity might be the content of the draft contract, the conditions to participate in the procedure, rejection of the bid, disqualification from the procedure, selection of the best bid, etc. We've got also second instance, the complaint to the regular court. It's also frequently used, but not so often as the appeal of the first instance, probably because it's a little bit more expensive, but also the standstill effect only refers to the appeal to the National Appeal Chamber, so to the first instance. During the appeal process of the first instance, the contracting authority cannot sign the contract. The characteristic of the public procurement market, as I mentioned before, is connected with the big number of appeals, being a natural process of conducting tenders in Poland. There are special rules that regulate mandatory contractual clauses, and since last year prohibits gross imbalance of the parties, which is very good for the contractors. For instance, the law introduced obligation to cap the contractual penalties and many other issues, which unfortunately I have no time to discuss it in detail right now. But importantly, I would like to mention that Ukraine companies are welcome to participate in Polish contracts as Ukraine is a party to the GPA agreement, international agreement. The contractors from Ukraine must be treated in the same way as European or Polish companies. So it's either possible to participate in the Polish contract as a domestic contractor, if, for example, the Ukrainian company sets the subsidiary in Poland, or as a foreign contractor directly or through a branch seated in Poland. All options are possible and allowed. What is some practical tip that I can share with you right now is that the contractors from Ukraine should remember that there are specific rules for foreign companies in terms of providing foreign documents. So all the requirements of the terms of reference have to be reviewed by the companies, foreign companies, in order to determine what kind of documents issued by Ukrainian agencies and other public bodies are equivalent to what is a requirement under Polish provisions. So thank you for now.
Yeah, thank you. It's really interesting to listen to you, especially when you said about a special court, public procurement court. It's really interesting institution, because in Ukraine we don't have a special court which view cases in public procurements. And as you mentioned, in Poland you have eZamówienia, special site, website, and if I'd like to take a part in tenders, I have to use this website. In Ukraine, we have central website ProZorro, and we have authorized platform. And if you'd like to take part in tenders, you need use this authorized platform. But am I understand correctly that Poland don't have this authorized platform? You have only one central website, eZamówienia.
Actually, eZamówienia, it's a new electronic purchasing platform. I think that it was started on November or something like that. Before we had something intermediate prepared by the Public Procurement Office, but also we had commercial platforms available for the awarding entities. Now the aim is to use the eZamówienia, which will unify the process and put all information in one place.
Okay, yeah, thank you for your speech. And our last speaker is Ernad Deni Kamaga, consultant for public procurement at IMTB Consulting, Germany. Please, Ernad, you're welcome.
Thank you very much, Mikita. I hope you can hear me all, because you told before that in Ukraine you had sometimes issues with the internet. This is normal in Germany, so it's a normal kind of situation that we have problems. But yeah, thank you very much. I'm really honored to be part of this conversation, and I also want to state my solidarity with the Ukrainian people, with Ukraine, and with all of you over there, because I myself was also in a similar situation when I was a child. I'm originally from Bosnia, and going through war, I know it's hard, and going through transition afterwards, I know it's even harder sometimes, the transition time, but I'm really hopeful that Ukraine and Europe will do it together, and that in a couple of years, Ukraine will be a really successful and good member of the European family. So thank you very much. Well, in regards to the procurement market in Germany, the European Union, I have to admit I didn't create a presentation because sometimes presentations tend to focus on some different level than to the presentation and to the talk that I currently do. So I had some couple of I tried to be some flexible because it would not make any sense to present here the normal regulations, EU regulation, because we had it a couple of times now. But what is quite interesting in Germany is that we have a federal structure. That means we have 16 different states inside of Germany, and this also means that we have different regulations in terms of public procurement. So everything below the threshold is regulated by the European regulation and a national regulation on the federal level. That means this is the legal base for every public procurement on a federal level below the threshold, and this also means automatically that is in the GPA framework. That means General Procurement Agreement, and it also means that it's open to Ukraine companies. What is also quite interesting, the European market, I did the research a couple of months ago, that the European market is actually an open market. It doesn't have restrictions on some states, but there are currently some some things going on in the Commission, because they want to introduce the International Procurement Instrument, it's IP, that shall actually limitate to some countries that don't have a similar approach towards European countries, the access to the European market. So generally speaking, I have to say that Ukraine companies are welcome and also acceptable on the most, actually on all public procurements below the European threshold. There is also one interesting thing. I supported I think about, can I say the name or not? I can say it. I supported a public procurement that is currently actually going on, that is consulting services about environmental issues in Ukraine, and it's financed by the GIZ, the German Development Corporation. And there are also a lot of procurements going on in the GIZ that are related to Ukraine. And if I say that Ukrainians are welcome, and I think that's a big possibility for Ukrainian companies to apply on this kind of services. There are also totally different services in terms of, I don't know, also some construction services, also some goods that are also procured. What I would really suggest to Ukrainian companies is to look up, especially on development agencies in the different European countries. There is a French one, there is a German one, there is also a Polish one. I have seen something a couple minutes ago that there is also some goods that are procured by the Polish Development Corporation, which is actually state-owned, as far as I know. Yeah, and I guess that this is something that can help the Ukraine companies to have their foot in the European market. Well, going back, what I would like also to talk about is about the e-procurement and the trends to make procurement more accessible, more digital. This is something that we currently really fighting a battle in Germany, because I see it on a practical level, because what we do as my company, we are actually not only consulting, but we are helping also the public institutions to get the public procurement on. The issue is they don't have the personnel who is trained using electronic devices, you know. They know how to use computer, but then there is a new system, there is a new publication system. And in Germany, as I said before, we have this federal structure. Every state has its own procurement regulation in regards to procurement below the threshold. And there are also that many portals. every state has a kind of a state procurement portal. We have also one at the federal level. We have some private procurement portals that are also working with some different states together. So it's quite complex to get an overview. And 2 years ago, there was a new law introduced. It's called it's related to the statistics. Before, we didn't have any statistics, and we hope that end of this year we'll have the first official statistic. How many public procurements have been procured in Germany? How many procurement bodies we have, and how much money was actually spent in the end. Current statistics that are not official says that about 30,000 procurement procurement bodies are present in Germany. That also at a yearly base, there are 2.4 million different procurements going on in Germany, and that about 400 billion euros were procured per year in Germany. So as we see, it's a really big market, and the issue now is how to control the market, and the state is still fighting with it. And we see in the last 1 year or so, the number of litigation is really increasing. And when I say increasing, it's not increasing about 10% or so, but more than 100 to 150%, which is really a lot. And talking about rebooks, they are now on a daily basis, because I do this job about 6 years. For about 6 years, I know when I started, a rebook was a big thing. You know, a bidder is complaining about something, and it was big. Now it's our daily job to work with rebooks and complaints. Yeah. To sum it up, what I think actually, first in regards to digitalization, the public procurement system, not only of Germany, but of the European Union, has to go more into digitalization and automatization. Actually, my master thesis was is automatization in the field of public procurement actually legally allowed in Germany? And unfortunately, it's not. That was my result, because there are some issues. But I think that's something that must happen, because the volume of public procurement is growing. We have more and more to be procured. The personnel is actually not there. Nobody wants to work for the state in Germany actually anymore. It's not that interesting. Everyone wants to go into the private sector. And I guess that the corruption can go much lower if we do some automatization on the process of public procurement, because my thesis is that a computer is not corrupt. Well, it can be corrupt if you make it corrupt, but then it's traceable who program it like that. Yes, and to sum it up in regards to Ukraine, as told before, I think that a lot of Ukrainian companies should have, not should have, but should use the possibilities, should use the chances, and also, especially after your victory, I hope, to rebuild the country, there will be a lot of money going into Ukraine, especially from European funds. And I think that you need to be more clever than we Bosnians were at the time, because all the money was spent on different consulting companies from everywhere in the world, but the money didn't stay in Bosnia. And I think that's something the Ukrainian companies have to learn from, and that the money that goes into Ukraine should stay in Ukraine. Yeah, if you have any questions, I'm open to that. Thank you very much.
Yeah, thank you very much. It was amazing speech without presentation. That's not a big problem for us. Yeah, thank you. Our time is over, our time for webinar, and I'm thankful for all of our speakers. You were amazing. Your speech, your presentation was brilliant, and we really appreciate it. Thank you very much. Thank you.